Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable John N. Harris, Judge, presiding. All persons having business before this court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
All right, it's more definitive about the state this time, right? What state you're in this time?
All right, good morning. Welcome to the oral argument session here at 5th DCA. As Marshall indicated, I am Judge Harris. I'm joined on the panel this morning by Judge Lambert and Judge McIver. A couple of housekeeping matters before we get started. If you have your cell phones or any other noise-making device on you, please go ahead and turn those off or silence them at this time so that we're not interrupted. We are being recorded. We are being live streamed on YouTube for whatever that's worth. Each side is going to get 20 minutes for their argument. The appellant can reserve as much of that as you would like for rebuttal. I will set it at 5 minutes as a default. If you want anything other than that, please let me know and I'll change the clock accordingly. All right, next case up, H&L Construction versus Mega Logistic, 23-232. Appellant, if you are ready, you may proceed.
23-3756.
Oh, I get the wrong one. 23-3756, thank you. Reading the lower court number.
Good morning, Your Honors. Alan Henderson on behalf of the plaintiff appellant, H&L Construction Corporation. This is a fairly simple case, Your Honor, and I say simple because I think everyone here agrees on what the law is in connection with establishing in personam jurisdiction against a foreign defendant. We've all seen the United States Supreme Court cases, but the two-prong analysis that the trial court is charged with conducting is as set forth in the Florida Supreme Court case Venetian Salami. That two-prong test is first, does the plaintiff's complaint allege sufficient facts to come within the ambit of the Florida long-arm jurisdiction statute? We, of course, contend that we did. The second prong of the analysis is whether or not the defendant has sufficient minimum contacts with the state of Florida to satisfy federal due process requirements. And those federal due process requirements have been stated by the U.S. Supreme Court in multiple famous quotations. I believe I probably quoted all of them on page 7 of appellant's initial brief, but they are, for example, the connection with the forum state is such that the foreign defendant should reasonably anticipate being hailed into court there, Worldwide Volkswagen. Or it must not offend the traditional notions of fair play recited in International Shoe. The case that we believe is most applicable to this case, however, is Burger King versus I can't ever say it, it's the Burger King case, where the Supreme Court listed 4 factors that the court should consider in determining whether or not personal jurisdiction is proper. So I think the first thing we need to do is let's look at the allegations in the complaint, and my complaint is in the record, pages beginning on page 10 of the record. And let me back up just one second. Rule 1.110B, Florida Rules of Civil Procedure, simply requires the complaint to make a short, concise statement of the grounds upon which the court jurisdiction depends. We certainly complied with that in paragraph 7 of our complaint. A verified complaint, of course, is not required under the rule. It's a short, plain statement of your case and why jurisdiction exists. The trial court actually acknowledged at the very beginning of the hearing, of the evidentiary hearing that was conducted October 25th of last year, the court acknowledged the allegations were sufficient. That's found in the record on page 259. Therefore, The hearing was then conducted to see whether or not the defendant had sufficient minimum contacts, but the court initially acknowledged the allegations were sufficient. He then got bogged down on whether or not the complaint proved the defendant breached a contract in the state of Florida. The issue, though, is, would this complaint survive a motion to dismiss for failing to state a cause of action for breach of contract? Absolutely it would. It's very easy to state the 4 elements to a breach of contract action. It's the existence of a contract, a breach, causation of damages, and the damages. And if you look at my complaint, you'll see each and every one of those elements is alleged. And it's alleged specifically, not generally. So if the complaint is not subject to dismissal for failing to state a cause of action, how could the lower court determine that my allegations were insufficient? But he did. The trial court ruled that plaintiff failed to meet its burden to sufficiently allege jurisdiction under Florida's long-arm statute, largely because the trial court concluded that we failed to allege defendant breached a contract in Florida, and he got bogged down, in my opinion, on whether or not the wire instructions on each and every invoice submitted to the defendant in this case had a physical address for the location of the bank account. This contract specifically says plaintiff will set up a specific bank account for this project only. That was done. It's undisputed, uncontroverted, that the situs of that bank account was Ponte Vedra Beach, St. Johns County.
Did the contract say it was to be in Florida, the bank?
It does not say that the account had to be in Florida, no, sir. However, the contract notifies the defendant, and the defendant knew they were dealing with a Florida corporation. The defendant knew that all of their contacts with the project coordinator was with a person located in Florida. So, no, the contract did not say he will open a Florida bank account, but it says he will open a bank account marked specifically for this project, which is what we did. And it was, in fact, located in Ponte Vedra, and the defendant sent 26 wires into that account over an 18-month period. Now, each invoice gave all of the wire instructions that you normally see, the routing number, the SWIFT code, beneficiary, bank account number. No, it did not state it's located in Florida. But does it really matter? Because the law in Florida is the same regardless. I mean, even the defendant in its motion to dismiss, footnote 2, page 6 of its motion to dismiss.
Well, I mean, you're saying the breach occurred because they didn't make a payment to the creditor who lives in Florida, and therefore that satisfies prong 1 of the pleading status. But Venetian Salami says failure to make a payment in and of itself does not get you past prong 2, minimum contacts. So that then leads to what's the minimum contacts that a Hungarian company having work done on a Hungarian embassy in Washington, D.C., who gets a car in Virginia, who rents an apartment in Washington, D.C., admittedly through your side's assistance, but because they're having communications with your client, with your owner who lives in Florida, that makes sufficient minimum contacts so that the judge was erroneous.
Yes, so, Your Honor, The base contract dealt with renovations to the Hungarian embassy in Washington, D.C. However, as Mr. Horvath testified at the evidentiary hearing, the contract also contemplated ancillary services relating to that project being performed by H&L in Florida, such as purchasing a car for the
The
defendant.
car was in Virginia, no, the car never was in Florida. It's titled in the name of some individual, not the corporate defendant. So they bought, you guys arranged to have a car for the Hungarian corporation, and that somehow becomes
Yes,
sufficient minimum
because they
contract?
purposefully availed itself of the pleasure of doing business in the state of Florida. They
Help us
utilized,
buy, can you help us get a car, and so that now gets them that gets in personam jurisdiction?
get us a car to be used by our employees in connection with the project
In Washington DC, right?
in DC. But it was,
Where all the work was, I mean, the actual physical work was done in DC. The renovating of the Hungarian.
yes, sir, absolutely.
Okay, and so all your employees who actually, whatever goes into the renovation itself, were up in DC doing the work for the Hungarian corporation under the contract here that listed your company in DC, actually.
The laborers, that's an accurate statement, Your Honor, but this man, Mr. Horvath, conducted more than 60%, I think was his testimony at the evidentiary hearing. He was the project manager for H&L, and he can perform services, a majority of services and hours, from his office in Florida, and the defendant knew that at all times. If you look at the affidavit of defendant's representative filed in opposition, filed in support of the motion to dismiss, nowhere does he say, I didn't know they were a Florida corporation. He doesn't negate the allegations in the complaint that H&L is a Florida corporation, and they knew it. So when you look at all of the services performed by the defendant, then it goes beyond failure to make a payment in the state of Florida, which absolutely, standing alone, if that's the only relevant fact, failing to make a payment, Venetian Salami says that's insufficient. But we have so many other contacts, so many other ancillary services that were performed by H&L that they should reasonably have expected to be held into court in the state of Florida. I think it's important to note that the defendant has no contact with any state in the United States. None. Never had a bank account, never had a physical address, never had a registered agent, none of that. So
Why wouldn't it be reasonable to suspect whether you're a Hungarian corporation or a California corporate defendant, that if something goes wrong regarding the renovation of a building in Washington, D.C., that the litigation regarding that would be in Washington, D.C., where all the witnesses of whatever construction work was done or not done correctly would be?
but none of those issues exist. And the law in Florida is that the cause of action accrues for a breach of contract where the default occurs. And in this case, whether it was
That's
in...
step one, though. Yeah, I agree. I mean, if this was if a defendant was based in Miami, that's one thing. But I mean, that's not the end of the minimum contact. That's not the end of the in personam discussion. That the non-payment is the breach. Therefore, you must come to wherever Montana or Florida or Texas or California, wherever the plaintiff corporation happens to have as a principal place of business. Is it? Why do we talk about minimum contacts? Why won't we just say, well, you didn't make the payment in Florida, therefore you have to be sued in Florida no matter where you exist as a corporate defendant?
Because those federal due process requirements have to
That's my
be
point.
satisfied,
Yeah,
of
right,
course.
There you go, that's my point.
Of course, and it's our position, Your Honor, that the defendant had multiple sufficient contacts with the state of Florida by virtue of, I want to get somewhere. Megalogistic corresponded with H&L representatives countless times over the 18-month period via email and telephone. All of the preliminary negotiations for this agreement happened with Mr. Horvath while he's in Florida. Megalogistic wired funds to H&L's bank
If those communications had happened while he was working remotely and traveling, say, on a working vacation, would that be relevant at all?
I don't think so, no, sir.
So how is it relevant that those communications happened with him while he happened to be in Florida?
Because the defendant knew he was in Florida. Therefore, the defendant knew he was performing services in Florida, and therefore they should have expected, upon a breach, to be held into court in Florida. I don't think it matters that services provided by Mr. Horvath or Gabriella Getsky could have been provided while on a working vacation or in another state. The fact is, and it's undisputed, they were not. They were provided in the state of Florida. And there are several cases. I want to preserve perhaps 4 minutes, but I think the case on point that is most beneficial to our position is the Banco case. It's cited on page 12 of my reply brief. It's Banco Inversion versus Celtic Finance. It's a 2005 fourth DCA case that involved a foreign country defendant from Spain. And even though the crux of that case was, even though plaintiff's principal logged hundreds of hours in Spain, he also logged hundreds of hours in Florida. And they held that was sufficient minimum contacts to establish personal jurisdiction. There is also a line of Fourth District Court of Appeal cases that deal with brokerage services. A California person engaging a Florida mortgage broker to get a mortgage on the California property. He failed to pay the broker. Personal jurisdiction was established based on that. And that string of fourth DCA cases, they are Metnick and Levy, Talmadge, Offer versus Ryson, and Stomar, all of which are cited on pages 16 and 17 of my initial brief. And at that point, Judge, I'd like to reserve what I have left for rebuttal.
You got it. Just under 4 minutes.
Okay.
On your rebuttal, I'd like you, if you can, talk a little bit about the dismissal with prejudice and how that happened.
Yes, sir.
Good morning, Your Honors. May it please the Court, my name is Austin Thacker. I'm here today on behalf of my client, the appellee in this case, Megalogistic ZRT. I want to address some of the questions that each of you asked, but I also want to start by highlighting the applicable standard of review, which I'm not sure the parties agree on entirely. We both agree that the standard of review as to legal issues is de novo. But the appellant did not explicitly agree that this court should defer to the trial court as to its factual findings when those findings are supported by competent substantial evidence. That's important because we do agree, and the appellee, or the appellant rather, concedes in its reply brief on page 6 that competent substantial evidence exists in the record. It's just they don't agree how that evidence should be applied or construed by this court and certainly by the trial court. But I reiterate that because this appeal, in my view, should be governed by the trial court's factual findings. And I'd like to go through some of those that I think are important to the questions you've asked and also to the legal analysis I want to go through.
There's no actual testimony from your side. There's affidavits, right?
Yes, sir.
So whatever that judge looked at, and however he weighed that, we're in the same position. I mean, the competent substantial, the weighing, the deference to the weighing is in relation to whatever testimony that was presented by your opponents and how the judge viewed that from a credibility or weight standpoint.
I completely
agree with that.
I completely agree with that.
You're not up here saying the judge really liked our affidavit, so you guys have to defer to the judge liking our affidavit.
No, sir. And,
Okay,
and
go ahead then.
to be clear, Your Honor, I think it's really important to just talk very quickly about that. We started, as my colleague pointed out, with a motion to dismiss. And at the beginning of our evidentiary hearing, the trial court judge did make the statement that there was some evidence in the record that might, in the complaint, have satisfied initially a prima facie showing. But if you continue to read the trial court transcript from that hearing, what the court says is, but then the defendant submitted an affidavit in opposition that raised factual issues, which was then countered by the plaintiff in a competing affidavit. And I think, I don't have the exact quote, but what the trial court essentially said right after that is, and so we're properly here at an evidentiary hearing to hear what you have to say, to listen to the testimony, to accept evidence into the record, and then I'm going to make a decision. And so,
Yeah, if the affidavits conflict and they can't resolve it as a matter of law, then you have an evidentiary hearing to determine the in personam jurisdiction issue.
agreed. And my point is that the trial court went through that exercise, spent time and effort to hear all of the evidence, and it made factual findings, which I submit to you were based on competent, substantial evidence in the record. And I think that's important because I'm going to go back to some of those factual findings as it relates to applying the law to those facts. And so I'll continue. I think it's important that some of the factual findings from the court, in its order in pages 214 to 21, or 221 of the record, include statements that the evidence received demonstrates the underlying contract did not require payment to be made at the appellant's bank account in Florida.
What does that matter? I mean, in a sense, yeah, there's nothing in there that says anything about where the payment is to be made. But then the law, certainly from this court, is that then if it's not stated in the contract, it is to where the creditor resides, which is Florida. And then that satisfies prong one. So you can spend your time talking about that or become more, perhaps address the issues. I think the issue, at least as to the breach of contract, was sufficiently pled regardless of what the trial judge thought. To me, this is more of a minimum context case. So you can guide your next 15 minutes accordingly.
I appreciate that clarity. The only thing I would say in response to that is where the contract is silent, I agree with the court's analysis that you just outlined. I think what the trial court ultimately
That's not my
found,
analysis, that's what actually the case law from everybody is.
and I understand. I guess what I'm saying is the trial court found that the contract specified a location for payment to be made, and it was wherever the plaintiff put in the invoices that were created throughout the project. And what the trial court said is they never sufficiently established that those payments were to be made in Florida. And in our response brief, there is a case that stands for the proposition that the exact type of testimony and evidence that we have in the record is not sufficient to establish the situs of the bank account. But putting that aside, I'll turn to the minimum contacts and due process arguments. It's our position that the trial court correctly held that my client doesn't have sufficient minimum contacts with the state of Florida, such that the exercise of jurisdiction would be improper in this case. Minimum contacts, as my colleague pointed out, involve three criteria. The contacts must be related to the plaintiff's cause of action or have given rise to it. They must involve purposeful availment of the privilege of conducting business in the state, in this case Florida. And those contacts must be such that the defendant could have reasonably anticipated being hailed into court in the state of Florida. That's from the Sculpt Chair case, the Future Tech case, both of which are federal cases from the late 1990s. The Burger King case, which my colleague relies on, says that a single unsolicited contact, random or fortuitous acts, or the unilateral acts of others do not constitute a purposeful connection between the defendant and the forum state. And I think it's important that we talk for a moment about the facts that relate to that specific legal standard. During the evidentiary hearing that the trial court conducted, it came out that the way these parties came together is that my client had gotten a contract to work on the Hungarian embassy in Washington, D.C. Through a third party they were connected. And my client ultimately hired this plaintiff because it was a Hungarian-owned business and they could do the work in DC and didn't need any type of licensure to do that work. Stated differently, my client had no interest in where H&L was organized, where its principal place of business was. All that it mattered to them was that H&L could perform construction work on a construction project on real property in Washington, D.C. And that's exactly what they did. As the trial court found, well, actually, let me back up. The Hansen case, which is a U.S. Supreme Court case from 1958, says it's essential that there be some act by which the defendant purposefully avails itself on the privilege of conducting activity within the forum state, invoking the protection of the law, which is very similar to what the Burger King case says later. The trial court found, and I quote, "Mega Logistics only contacts with Florida were its dealings with H&L in connection with the embassy renovation project in Washington, D.C., end quote. Later, the trial court says, the facts appellant asserts established personal jurisdiction over my client consist of, quote, contracting with a Florida company, making payments to H&L's bank accounts in Florida, and communicating with Mr. Horvath and Mrs. Getze as they provided support services that could have been provided from anywhere, including in Washington, D.C., in Florida, end quote. Lastly, as it relates to this legal analysis, the court concluded that all of the contacts that my client had with the state of Florida are owing to the unilateral action of H&L. And so I think it's important to talk about...
Your client never called them? The plaintiff was always calling you guys?
I can't answer that question. I'm sure there were phone calls made both ways, but it's a construction project.
Right.
And I don't think that making a phone call to someone who might happen to be in Florida or might happen to be in any place is sufficient to establish purposeful availment on the part of my client.
That's the actual nub of the whole case.
I agree.
Okay. I mean, we're kind of dancing around a little bit. I mean, there's no... there was two, subsection 1 and sub 7, operating, conducting, engaging in, or carrying on a business or business venture in Florida. Your client wasn't doing that. They had a contract here to have work done in Washington, D.C., and they have some phone conversations, et cetera, with the plaintiff's principal. So that's not. I'm trying to help you. That's not carrying on a business in Florida. So that to me strikes that. We're now down to number 7. Did you breach the contract in Florida by not making a payment to a Florida corporation? And are there, which would satisfy prong 1, but that's not enough under Venetian salami. So then we go to the minimum contacts, and what was done as alleged by the plaintiff that apparently did occur, is that enough as basically a matter of law to justify in personam jurisdiction over your company? Isn't that what this case is about? Isn't that not what this case is about?
I think that's a fair assessment of how this court could ultimately decide the case.
How is it not? I mean,
no, I think...
That's the whole, I mean, you agree that the case law is if there's nothing in the contract about where the payment is to be made on a contract, that the debtor seeks the creditor, who happens to be a Florida corporation. Therefore, that's proper, if it's a breach. If you guys owe the money, that's a breach, and that satisfies prong 1 of the 2-prong jurisdictional analysis. Do you agree with that? Do you agree that's what the case law says?
If the contract is silent, yes.
Yeah, that's
yes,
what
Your
you
Honor, I
said.
agree
The contract is, as yours is. Your contract doesn't say all payments are to be made in Florida, right?
It doesn't say that, but respectfully, it says where the invoices say that payment is going to go. And what the invoices say is accounts ending in certain numbers. And you can look at the stipulation of facts, and It may turn out that those are in Florida, but the trial court didn't believe that that was sufficiently established. And I know you don't want to spend our time talking about that.
Well, you could spend your time as you want, and as you could probably glean from this, you're wasting your time with me on that. Certainly my gentlemen colleagues, if they think that's important, they will address you appropriately. It seems to me that we're past prong one on subparagraph 7, which to me is a dispositive issue, whether there's minimum context, whether the evidence they presented, the judge called it right or not. It seems that's a good use of your last 750, but you use it as your time, as you deem appropriate.
Well,
that's what I'd like to know the answer to, but.
I think the answer is there are not sufficient minimum contacts.
And now, all right, now we at least got through that hurdle. Why?
Well, I think if you look at the record,
I have. Go ahead.
the facts are this. My client hired the plaintiff and the appellant in this case to work on a construction project in Washington, D.C. And like in nearly every construction project, there are people who provide support services who work in various locations. They might be in Florida, they might be on the other side of the world, but those people do bookkeeping, they do project record keeping, they do accounting services, they do all the different things that are necessary to make a construction project go, because there is a lot of paperwork. But as the appellant, not explicitly, but I would put forward to you, essentially agreed with, those services can be provided anywhere. And going back to what I said a minute ago, my client didn't hire H&L because it was in Florida. They hired them because they could work on the Hungarian embassy in Washington, D.C. And it just so happened that they ended up having people provide support services, which the trial court pointed out could have been provided from anywhere in Florida. And we're talking about purposeful availment. My client didn't care whether it was Florida or some other state. They didn't anticipate, and there's nothing in the record other than a bald accusation, that they ever contemplated being hauled into Florida to be sued. If this case were pending in Washington, D.C., we wouldn't be standing here right now, literally and figuratively speaking. And so I think that's the issue. The trial court made a factual finding that our only contacts with the state of Florida were by virtue of this project, and that those contacts were in the nature in Florida of support services that could have been provided anywhere. And so if Your Honor is looking for facts that would allow it to find the trial court rightly decided that issue, those are the facts I would point this court to.
Let me jump to steal some of Judge Harris's thunder here, which puzzled me as well. Why? I mean, in order denying or granting a motion to dismiss for lack of in personam jurisdiction is clearly a non-final order appealable under Florida Rule of Appellate Procedure 9.130. We get those occasionally here, and we have jurisdiction to consider that. We have express jurisdiction to consider that. Why is there a final judgment of dismissal with prejudice? And in the context of me asking that, it seems to me that you're going to tell us at the end of the next 440 that you want us to affirm. And if we did do that, and these guys want their $1 million, and they say, well, I guess we got to go to D.C. after all to try to get our $1 million, are you guys going to waive the final judgment of dismissal with prejudice in the face of the Washington, D.C. trial judge and say, hey, case is already over? Yes or no?
I would certainly want to.
Why should you? Why should that be a proper thing to do? I have no idea why the final judgment of dismissal with prejudice has been entered here unless they said to do that, Judge. I mean,
I can't, in all honesty, I can't. It doesn't.
And Judge Maltz, it just kind of as part and parcel of his separate order, he said, and oh, by the way, here's your final judgment?
Yes, Your Honor. And to be clear, we did not ask for that. I don't recall that we submitted a final judgment to be entered by the court. I could be wrong because I did not focus on that much, to be honest, preparing for today.
Were you the trial attorneys?
I'm sorry?
Were you the attorneys at the trial court level?
Yes, sir.
So you don't remember if you submitted one?
I don't recall submitting one, and that's why I'm...
Remember he asked for one to be submitted?
I don't recall that one was asked for, no, sir. And so I think your larger question is, why did the court do that, and would that have been proper? Are we going to ask you to affirm?
Well, I assume you're asking us to affirm. If you wanted us to reverse you to conceded error, we wouldn't be having our discussions today.
I do think affirming...
We understand you want us to affirm. Go on to something else. We get that.
So
you think Judge Maltz called it right because the evidence was such that did not show to him sufficiently that your client has sufficient minimum contacts with the state of Florida to be hailed in here on a breach of contract action?
yes, Your Honor. And what I would say is, even if the trial court got it wrong on the long-arm jurisdiction, which I understand Your Honor may believe is the case.
I don't believe one way or another. I just want to hear what you got to say.
Even if that's true, we do believe that the minimum contact standard has not been satisfied. And I think I've spent some time talking about that. And so I want to turn to kind of part 2B, if you will, of this analysis, which is that even if the minimum contact standard were met, which it is not, the application of jurisdiction here would violate traditional notions of fair play and substantial justice, which is the second part of that prong that we have not really spent any time talking about.
How is that not the... You have to have minimum contacts, and if you have minimum contacts, then you should reasonably expect to be hailed to Florida to defend the lawsuit, right?
Understood.
There's not a third prong of, and oh, by the way, even with minimum contacts, it really, really ain't right, so you can't have us here anyway.
Well, I think the way that the case law reads, there's an extra element there, if you will, that courts should consider as part of this entire second prong analysis, whether exercising jurisdiction in this state would put a burden on the non-resident.
Well, sure it would. They're going to have to come from Hungary to defend themselves.
And so that was really where I was headed. I was going to cite the Future Tech case from the Southern District of Florida. I was going to lay out the 5 criteria that they set forth that should be considered in evaluating that. But our position is that there would be tremendous burden on our client.
Well, where should they be sued then?
Washington, D.C.
That's so coming 1,500 miles south is that much more burdensome to a Hungarian company?
Well, I think if we're going back to what you said about minimum contacts and reasonable expectations about where they might be hailed into court, it's a construction project on real property in Washington, D.C. That's where they would have expected to be hailed into court.
That's where it makes sense. I mean, but you're telling me it's a burden to have to come, you know, if they got to come someplace, I mean...
Well, and the rest of those factors are...
Expect to be sued in Hungary, did they?
No. But the rest of those factors are Florida's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective relief, which obviously they believe this would be most effective, and the other factors that are there. We don't think they apply. And so let me just conclude with this. We do not believe that appellant alleged sufficient facts to bring my client, the appellee, within the ambit of Florida's long-arm jurisdiction. But even if they did, we don't believe that the minimum contact standard, the second prong, has been satisfied. And for these reasons, we ask you to affirm the trial court's order granting dismissal with prejudice.
All right,
Thank you for your time.
Thank you, Counsel.
May it please the court, focusing on how the dismissal with prejudice came about. I'm not sure I was flabbergasted, but the very last page of the court's order specifically states motion to dismiss based on lack of personal jurisdiction granted with prejudice. I filed a motion for rehearing, and in my motion for rehearing, I brought up, why is this dismissed with prejudice? And because that was never discussed or argued, and in my motion for rehearing, I said, certainly I can make additional allegations demonstrating their contacts with the state of Florida. The motion for rehearing was denied summarily, no further evidence or argument.
You brought up to the judge saying, look, whatever you decided on the in personam jurisdiction, you can't dismiss the case with prejudice.
I did, and it's in plaintiff's motion for rehearing. It's in the record, pages 223 to 229. So it would be 227. It's paragraph 9 of my motion for rehearing, Your Honor. And
So, I mean, the worst case scenario for you here should be that if we affirm, you ought to be able to go up to Washington DC and litigate if that's the choice that your client makes.
I would go one step further and say I shouldn't be precluded from filing an amended complaint in St. Johns County first. A large portion of Judge Maltz's ruling stemmed on the fact, and it's in his order clear as day, that because you failed to allege ultimate facts establishing that the defendant breached the contract in Florida, I'm not going to assert personal jurisdiction. And I want to go back and point out to the panel the competent substantial evidence that was adduced at the hearing and is reflected in the transcript. And you can start with the affidavit of Mr. Horvath, which is in the record on pages 162 to 166. And I believe when you take it, the whole picture together, you'll see that the minimum contacts test was in fact sufficient. Megalogistic corresponded with H&L countless times via email and telephone, asking them to perform services for them while the project was ongoing. They repeatedly wired funds to Florida. Megalogistic, they didn't just ask H&L Auto Sales, a division, to buy a car. They purposefully knew he had a wholesale business license as an automobile dealer. They purposefully had the car registered, titled, and insured in the state of Florida. To me, it's hard to imagine a more concrete example of purposefully taking advantage of the laws of Florida. And when you do that, don't you have a reasonable expectation that if you breach a contract, you're going to get held into court within the state of
So
Florida?
because of the car, if they don't make a payment for work done in a Washington DC a construction project, they should assume because of this Florida car purchase that they should be in Florida on a breach of construction?
As well as the other ancillary services provided by H&L, which included loaning them money. They didn't have a bank account. They didn't have a way to pay for things. It included finding them an apartment. They performed several brokerage-type services for the defendant, all from Florida. And I would just like to cite the case to cite the panel to a 5th DCA case, which I believe is on point. In that case is the XL Vision versus Holloway case. It's a 2003 5th DCA opinion. And in that case,
You need to wrap it up, sir.
Yes, sir. The 5th DCA opined that because the agreement was not an isolated transaction, but was for ongoing services by Holloway in Florida, the agreement gave rise to ongoing relations between the parties. The defendant solicited the plaintiff's employment, and the agreement focused on and had future consequences in Florida. All of those things occurred in this case. Thank you.
All right, thank you, counsel. We will take this matter under advisement. Court stands adjourned until 11 o'clock.
All rise.